My name's Mike Squirrell. I'm a partner in Wilkin Chapman Solicitors' corporate and commercial team. My aim today is to focus on topics which frequently we see affecting our clients and to offer hopefully a refresher and potentially some action points for you today. I'm going to focus on three issues: internal governance, protecting your brand, dealing with other businesses and consumers. Because of the time available, if you have any questions, please come and speak to me at the end of the speech. Firstly then, turning to internal governance. I appreciate that many delegates here will trade as sole traders or partnerships, but for the purposes of today's talk, I focus solely on limited companies. When businesses are set up, the documentation for the internal governance can often be put to one side because, bluntly, funds can be better spent than on legal fees. But as a business matures, it is important to ensure that your internal governance is up to date and relevant. For a limited company, the governing documents are the Articles of Association, or Articles, and with the option of a Shareholders Agreement. The Articles in law are a contract between the company and its shareholders, and is sometimes referred to as the internal rulebook. They're on the public record and available for everyone to view at Companies House. A Shareholders Agreement, by contrast, is a contract between the shareholders themselves. It is enforceable against the members and is a confidential document. So why would you need a shareholders agreement? Sometimes the management shareholders, so that could be the majority shareholders or the shareholder directors, would want the rights between themselves set out in a different document to the rights and obligations of the other members, which would be set out in the articles. Similarly, if you have your dividend policy, you would want that off the public record, and for technical reasons, the right to be appointed a director can only be included in the shareholders agreement as opposed to the articles to be enforceable. Particularly when you're looking to issue new shares, then it's important to review your internal governance before issuing or transferring those shares to new members. And the key provisions you would tend to see in articles are as follows. Firstly, voting rights. If you're issuing shares to family members or employees, you may want those shares to be non-voting shares, but with the right to receive a dividend. And to that effect, you often see alphabet shares, so your A shares might be your voting shares, and the B, C, D shares, etc. would be non-voting shares. The transfer provisions will regulate who can become a shareholder. For tax planning purposes, you may wish to have the ability to transfer shares to spouses, partners or children, but then those family members would need to follow the same direction as the original shareholder if that original shareholder then wants to transfer their shares. When issuing shares to employees, you often tend to see good and bad leaver provisions. With good leaver provisions, if an employee exits the business, they would receive full value for their shares. And a good leaver is often classed as someone who needs to leave, say because of ill health or redundancy. With bad leaver provisions, an employee would receive a significantly discounted amount for their shares. A bad leaver could be someone who needs to leave because of gross misconduct, or if the aim of issuing shares to employees is to retain staff, then you could class them as a bad leaver if they want to sell their shares within, say, 5 or 10 years. A couple of points to note on directors. If a company adopts the model articles under the Companies Act, which is the default position if you don't adopt bespoke articles, then the chairperson of the board would have the casting vote. And this could have the effect that in a company with 2 directors and 50-50 shareholders, one of the directors arbitrarily will have the casting vote and control at board level. With a company that has a sole director shareholder, you would want to see the right for their personal representatives and authorised representatives to appoint a director in the event of that director's death or incapacity. Because without that, you would need to apply for a court order in order to appoint a director, which can be time-consuming, and the company would be unable to operate in the meantime. Moving on then to protecting your brand, there are 4 principal types of intellectual property which a company would generally come across. These are copyright, trademark, patents, and design rights. Patents are used to protect particularly innovative designs or inventions. For many businesses, patents won't be applicable. However, if you do have an idea or a product which you think may be patentable, it's important only to disclose information of that product or idea to third parties with a non-disclosure agreement, or else it won't be able to be protected if the idea gets out into the public domain. Design rights are used to protect 2D and 3D shapes and can cover anything from typefaces to designs for cars. And they're useful to prevent copycat creations. Copyright, sometimes referred to as the representation of original thought, covers anything from a child's drawing to a software program. Copyright merely subsists, and so there is no central register to register copyright. Oftentimes you will see people using the copyright sign. This adds nothing in law, however, it can dissuade copying, and if the third party was looking to license your copyright, then it notifies them of who they need to contact to do so. One point to note is that the creator of a work will, unless they're an employee acting in the course of business, own the copyright, and therefore if you're commissioning anyone to design a logo or a website or to take photographs for your business, then make sure that under that contract the creator assigns the copyright to you, or else you would only have a license to use that work. Moving on to trademarks. Trademarks distinguish one trader's goods and services from another's, and are useful to establish an identity for a business independently of the owner. In the UK, we have two regimes for trademarks, unregistered and registered trademarks. With an unregistered trademark, you still have rights in your trading or business name if it is not registered. However, it is much more difficult to enforce your rights in the event of a third-party infringement. You would need to rely on the action of what's called passing off, which in short is very costly and is much more difficult to demonstrate breach than it is for the infringement of a registered trademark. Registered trademarks give you the right to prevent third parties from using identical or confusingly similar marks. Trademarks give you a 10-year exclusivity period to use your mark, which can be renewed indefinitely. The first ever UK trademark, the Bassett Company Pale Ale sign, was registered on the 1st of January 1876 and is still on the register to this day. It can cost as little as £170 to register a UK trademark in one class. And in addition to giving enhanced protection of your brand in the event of an infringement, it can be useful to have a registered trademark to exploit that if you're selling your business, or you can license that trademark, which could be useful, say, if you're going down the franchising route. So the ability to register a trademark is essentially couched in the negative, so you can register a trademark unless there are absolute or relative grounds for refusal. The absolute grounds relate to the nature of a trademark. If a trademark is too descriptive, or in most circumstances it contains geographical references, then it would be incapable of registration. Some rather far-fetched examples are the trademark greengrocer would not be registrable in the field of food retail, but it may be registrable in, say, the field of computer games. Similarly, Lincoln Law would not be registrable by any law firms in the region because many businesses would have should have the ability to use that because it's descriptive and of the geographical region. The relative grounds of refusal relate to existing trademarks, so it's important to check the register before making any application. There are 45 classes of goods and services in which you can register a UK trademark, and these are categories of goods and services grouped together with similar types. The relative grounds of refusal essentially say that if your trademark is identical or similar to an existing mark, it's to be registered in classes of goods or services which are identical or similar, and there exists a likelihood of confusion between those marks, then it won't be registerable. Trademarks can be either text or logo device marks, so this could be Wilkin Chapman, which we registered as a text mark a couple of years ago, or if you see the giant duck wandering around Lincoln, that's Darcy Duck, which is owned by the Lincoln Students' Union and is a registered trademark. If you have any concerns over registrability of a mark, or you have a particularly distinctive design, then you can look in the first instance to apply for a logo-only trademark, such as the engine shed trademark shown here, and as the goodwill in your brand builds, then you can apply later for a text mark, because the text mark offers much greater protection than a logo mark. Lastly then, dealing with other businesses and consumers. A large proportion of our commercial work centres around contract drafting and negotiation. So irrespective of the nature of goods and services that are being offered, then negotiations tend to centre on the same principal clauses. Firstly, obligation to supply and purchase. Well, this might sound too obvious, but to be worth mentioning, but in heavily biased or potentially badly drafted contracts, there may be an obligation on parties to supply or purchase goods when you wouldn't in reality want to be bound. For example, can the minimum supply obligations be met? And how much notice does a party need to give in order to order goods? If it's a very short notice period, can that be fulfilled? Termination provisions are important, so is a contract terminable at will, is there a notice period to give to terminate the contract, and does that fit in with your business plan? A party should have the right, ideally, to terminate the contract if the other party is in material or persistent breach of the contract. And as a supplier, you would want the right, if you haven't been paid, to terminate or to suspend supply of goods, which wouldn't be the default position if this isn't stated. The limitation and exclusion of liability in a contract is perhaps the key clause from a risk perspective. Many types of loss are capable of being excluded or limited in the contract. These include direct losses, such as the non-payment of a due debt, or indirect or consequential losses, such as the loss of reputation. Some liabilities can't be excluded on a matter of law or public policy, including death or personal injury caused by negligence. But other purported exclusion or limitations of liability clauses are subject to the reasonableness test. In business-to-business contracts, it's easier to exclude or limit liability compared to business-to-consumer contracts, where such limitations and exclusions are looked on more onerously. It's important to note that the default position if a contract is silent is that your liability will be uncapped under that contract. So it's important to try and get a cap on liability so that you know what your overall exposure will be under a contract if things go wrong. Often you see this being phrased as 1 to 3 times annual fees as a starting point, but a cap does need to be justifiable in order to be enforceable. Sometimes it can be good to link the liability, the cap on liability, to insurance. So if you check with your insurer that your liability is covered, then you can offer a much higher cap, and therefore that would be more likely to be enforceable, but still knowing that your aggregate liability is known. Lastly then, indemnities. These can be particularly onerous, and essentially they provide for a pound-for-pound compensation, underwriting all of the other parties' loss under a contract, and that would include, say, legal and accounting fees incurred on a claim. Unlike the position without an indemnity, the recipient of an indemnity under a contract would be under no obligation to mitigate or reduce that loss, and therefore costs can rack up quite considerably. I would say that you should avoid giving indemnities unless there is a good reason for doing so. For example, if the ability to use intellectual property supplied under a contract is crucial to it, then you might legitimately want an indemnity from the supplier that the IP doesn't infringe the IP of any third party. So finally, thank you for your time today. If you have any questions, please come and speak to me at the stand, or you can contact me on the details shown on the screen. Thank you.